Hello, this is Ian Brodsky with Windy City Legal, and I wanted to answer the question of, can I transfer real estate to a relative without going through a probate proceeding? This question comes up in estate planning in a couple different formats. Recently I had one couple asking, essentially saying, hey, we just have the house and there's not a lot of other stuff, but we want to make sure we're not creating a probate situation for the kids. On the other side, some people come in with multiple parcels of real estate, lots of assets, sometimes other concerns, and so that can be a flavor as well. And there are a couple of different strategies to deal with this. Before we get into the meat of them, if you have this particular question or something else with estate planning, you can always reach out to me at windycityestateplan.com. If you go there, you can pick a time for us to chat. That's windycityestateplan.com. What are the strategies that we can look at to address the issue of transferring real estate or leaving real estate to a relative without having it to require a probate proceeding to transfer that real estate? A couple different strategies, and keep in mind, no one strategy fits every situation. So we'll talk about a couple here, and ultimately it would be necessary to pick what's the best, most efficient strategy for your situation. So the first is a trust. Trusts have a lot of use when dealing with real estate. They can receive title, they can hold the title and either transfer it or transfer the ability to use it to one or more beneficiaries. It's a useful thing not only to avoid probate, but to address the situation when the beneficiaries may be minors, or if there are other concerns that are going on, for example, need for some kind of asset protection, may be a common consideration as well. So trusts handle these very well. It's just a matter of getting the trust set up and dealing with the cost to do the setup and transfer the real estate in. Of course, it's necessary to transfer the real estate in to the trust in order for the trust provisions to take effect. But once that cost is out of the way, then the trust is a very efficient vehicle for this, and it is it is a cost that would be one time, and certainly is going to be much less than the cost of having to deal with a probate proceeding. So that's one option. Another is a land trust. A land trust is a very specific kind of a trust, and its sole purpose is to administer the title for the real estate. It doesn't consider other assets. It doesn't help out when there are other special situations that need to be taken into account, or other kinds of things that you might want to address in a regular living trust. But it is an option. It involves a third-party corporate trustee. Typically, the land trust company is affiliated with a title company or a bank or insurance company, something like that. And although they are easier, quicker, and cheaper to set up in the beginning, they will have not only annual fees, but also fees anytime there's a transaction into, out of, or changing the trust. So those costs can add up over time. There is an advantage that the land trust may provide a little bit more privacy when that's desirable, and the land trust is also an efficient vehicle for transferring title to the beneficiaries. A third option is what's called a transfer on death instrument. This is not a trust. It's something that is prepared and recorded. It's pretty cost effective and flexible, but it does not provide any solutions if the beneficiary would be a minor child. And it also does not really help out when there are needs for asset protection for one reason or another. So those are some disadvantages that go with it, but they can be useful, especially in more straightforward situations where the estate is smaller and the clients are looking for a efficient way to transfer the real estate and avoid probate for that particular asset. There are a couple of other situations that we should probably talk about as well. One is joint tenancy, which is a way of holding property, and the concept there is that with a joint tenancy, each of the joint tenants has an undivided share of the real estate, and the last surviving joint tenant ultimately will hold the 100% of the real estate that is held by joint tenancy. And so if they are the last surviving person, they will hold the whole real estate outright. There will be no probate for upon the passing of the prior joint tenants, but there will be a probate proceeding when the last owner who has the whole thing outright passes away, unless he or she has subsequently put into place some other kind of estate planning to avoid that probate proceeding. And then finally, sometimes we get the question with real estate, can we just put it into an LLC? And while LLCs have certain uses in the context of administering real estate, especially with rental properties, the LLC is not really something that's going to help you avoid probate. First of all, if the real estate has a mortgage on it, you may not even have the option available to you because the LLC is a separate legal entity. Transferring real estate to it may violate terms of the mortgage because essentially it would be transferring collateral to a different legal entity, and banks really don't like when their collateral gets given away. And so that would enable them to potentially request repayment of the entire balance outstanding or other remedies that may be in those loan documents. The other issue with the LLC is that although you are addressing the problem of an individual owning the real estate, they now are going to own a different asset, which is most likely going to be over $100,000 in value, and especially in combination with whatever other assets they may own. And because of that, those membership interests in the limited liability company are going to become probate assets anyway. So you don't really avoid the probate issue by simply transferring the shares to the real estate into a limited liability company. Again, if the LLC is an option that's available, there may be other estate planning to deal with the transfer of the LLC shares, but it would be, it on its face is not enough to avoid the probate proceeding without something else to address the ownership of those LLC interests. So as you can see, there's advantages and disadvantages to the various options. There's no one solution that's right for every particular situation. And this is where it makes sense to really sit down and talk with an estate planning attorney and make sure that what you are implementing is right for your particular situation. If you would like to address that question or anything else with estate planning, again, please feel free to visit us at windycityestateplan.com. Again, windycityestateplan.com, and you can pick a time. We'd like to hear from you. And that's it for today, but I just want to leave you with the thought that estate planning is not something that is a simple answer for every solution. You really want to make sure that you are setting up something that is going to be right for your particular situation. So again, if you have questions, if you want to reach out, please visit us at windycityestateplan.com. Thanks so much, and we will catch you next time.